So thank you for attending. I'm Jael Duarte, the tenants advocate for the Coalition for Tenants' Rights. I'm speaking from the unceded Wall of Stick territory. Today I'm going to talk about the current legislation about termination of tenancies. So I have a presentation, so I'm going to share my screen. What is it? Okay, I found where I can share my screen. Okay, it's here. And so that's the presentation. Okay. So, okay. I start the presentation. Okay. As I said, my name is Jael Duarte. So we are talking today about the current relation for the termination of tenancies. Oh, I put the date. Today is not July 18. That was last time. Wait, she didn't change the date. Okay. Service of notice for termination. So it is important that the notice of termination have rules. It have to be written and it have to be served. That means the person have to know if the lease is year from year to year, the notice of termination has to be served either by the landlord or the tenant. So either way, whoever wants to terminate the lease, have to be served 3 months before the expiration of the lease. If the lease is month to month, so it has to be served 1 month before the expiration of the lease. And if it's week to week, at least 1 week before the expiration of the lease. So if you don't want to continue another year, you have to serve the landlord 3 months prior. That is really important. Of course, you can always talk to your landlord, but well, it's up to the landlord if they allow you to terminate before. We're going to see when the tenant can terminate without this delay later in the presentation, or also the landlord, of course. The requirement for the notice. So the notice of termination has to be in writing, have to be served by the landlord with the name of the tenant, have to state the address, have to say the effective date of the notice. So if it's at least 3 months before, so for example, you have to say, so the notice is now and it's gonna be for this date at the end. Shall state the reason for the termination. So if it's required by the act, and that is we're gonna see some reasons for the tenant to terminate before or the landlord to terminate before, and shall be dated and signed if it's the landlord who's terminating the contract, or an agent or representative of the landlord, or by the tenants if the tenant want to terminate. That section. So when you don't have to wait for the 3 months, the month, or the week. If it's because of domestic violence, for example, intimate partner violence, sexual violence, criminal harassment, a tenant believes that he or her own safety or a dependent child of the tenant is at risk if the tenancy continues. So if there is this situation, so the tenant has to serve the landlord a notice of termination and a document prescribed by regulation that the tenant has been subject to domestic violence. So unfortunately, the law obligate, I know it's not easy. My experience, I also sometimes work with victims of domestic violence, intimate partner violence, and it's not easy to go to the police. It's not easy to start charges, but well, to terminate the contract, you need an evidence. You need something to show that that is happening. And it has to be an authority saying that that is happening. So if something is happening like that, well, you have to go to the police, you have to denounce, you have to have evidence that you are victim and you are at risk or the child is at risk. Another exception is the premises are let year for year. You can, so the notice of termination document shall be served at least 1 month before the expiration. In the case of a term tenancy, the notice of termination and document referred has been served at least 1 month before the expiration. So it's depending, it is a fixed tenancy that, so well, I'm talking about, sorry, I'm confusing now. I'm talking about the last exception. So this is a continuation of the section. And that is, I don't think the legislation is recognizing the urgency to leave a place when there is a person victim of domestic violence or the crimes we described before. Because if you have a leave year per year, you have to give the notice 1 month before. So if you are a victim of domestic violence, you have to denounce, you have to go to the police, and you have to serve the tenant, the landlord, 1 month before. If it's a fixed term tenancy, you have to serve at least 1 month to be effective at the last day of that month. So you still have to pay the month. And if it's terminated under this section, so the landlord is not entitled to compensation. It's not ideal, but it's what it is. So when a tenant make a complaint against the landlord, any complaint, and there is after a notice of termination, the tenants have to advise the residential tenancy officer in writing within 15 days after the receipt of the notice. So you receive the notice of termination, you have to denounce, you have to complain. 15 days, you only have 15 days, 15 days with weekends. So 15 days calendar. And the landlord has to explain why they serve this notice of the termination, and have to justify that it's not because the tenant made a complaint before, for example. Let's say, I'm gonna say an example. The tenant is complaining about the rodents in the apartment. So it has to be, and the tenant don't want to leave or just wanted that to be fixed. There is not an agreement to leave, and there is a termination because the person did a complaint, or for discrimination, for example, or the Human Rights Commission, things like that. When a tenant can terminate the contract, the tenant can terminate the contract if the continuation of the tenancy will cause extreme hardship. So the tenant, because of deterioration of tenant's health. So I suggest, there are many situations where recently someone was asking me about, I have to leave New Brunswick because my dad needs help in another province. It's an elder and he needs me. So what I do, my suggestion to this case is justify extreme hardship, tenant's health, tenant mental health. So, but you still have to do an application to the residential tenancy officer. You still have to say a day specified in the notice, and if the residential tenancy officer agree with you that there is extreme hardship, so in your health, so the landlord is not entitled to compensation. Oh, what happened here? Okay. On the other side, for the landlords, there is a limitation of the rights to terminate the contract before. So the landlord shall not serve a notice of termination of the tenancy. So that is aiming to have stability for the tenant. So once you are in the apartment, there are only some reasons that the landlord can terminate the contract. One, it is the landlord in good faith will be occupied in at least 3 consecutive months by the landlord spouse, the child of the landlord, a parent, or a parent of the landlord spouse. So a landlord cannot terminate the contract, cannot say, okay, next year you are not continuing, unless justify that these persons or the landlord himself, herself, or the spouse, or child, or parents, or in-laws are living in the apartment for 3 consecutive months at least. If the premises occupied by the tenant will be used other than residential, for example, commercial, for at least 3 consecutive months, or if the tenancy arises an employment relationship between the tenant and the landlord, and the employment relates to maintenance or management and look of the premises. It's not any contract. Maybe I have a contract, I am a worker, and the landlord say, hey, to help you to settle in the city, you can rent this apartment and renting. That is not what we are talking here. That we are talking here when the person is the janitor, for example, of the building. That it is a management of the premises. That is when it's possible to terminate from the landlord if the work relationship ends. Complaint. So when there is a termination and you feel that it's a complaint, I will go by default, do a complaint. Because you only have 15 days. So you don't want to lose that. If you lose these 15 days, it's like you are accepting anything. So you have these 13 days, so the residential tenancy officer shall set aside the notice of termination if the reason from the landlord is not enough, if the landlord cannot justify, and if the residential tenancy officer say, yeah, that is a legit reason, this according to the law, like the reason I just said. So the residential tenancy officer may vary the day of the termination of the contract too. So if the landlord was served a notice of termination within 2 months after the tenancy terminates and doesn't occupy, so the tenant have 2 years to ask for compensation. The residential tenancy officer who receives an application for compensation will conduct or may conduct an investigation. And after they can say, okay, I order there is compensation here because in these 2 months, the apartment, for example, wasn't occupied by the spouse of the landlord, like the landlord said. So what happens if the landlord wants to renovation or repair? The landlord have to ask permission to the residential tenancy officer and have to have a written approval from the officer. Without this approval, they cannot, and they have to justify that the renovation, it is in a way that is not possible for the tenant continue living there. It's so big, the renovation, that is not possible, or the repair. So, and if the tenant see that in 2 months they are not starting to renovate, the tenant have 2 years to ask for compensation. So what is the moral here? If you are evicted, if you have to go from the apartment because a renovation that it was approved by the officer, by the residential tenancy officer. So, and if you see that in 2 months they didn't start, you can ask for compensation. So keep the receipt of the moving. So you can justify all the expenses you had because this termination. Overholding tenants. So when a tenancy has expired or terminated, a new lease has not been signed, if the landlord accepts payment of the rent, it will be a new tenancy agreement. And it depends on how you pay it. But it has to be first. It's not like a year and after a year is month per month. No, it doesn't work like that. If you have a contract of a year, it's going to be always a contract of a year. It is not terminated. But if you had a notice of termination and you continue paying, so maybe it will be a year. It will be a year, it will be a month, depending of the method of rental payment, depending how you are paying. That is why it's good to complain when there is a notice of termination. So to be clear, and not unless you think it's good for you to change that term of the contract. Ending a lease early. So a tenant who doesn't pay rent, a landlord may serve the tenant a notice to vacate. So first the notice to vacate. I did a webinar last year that you can find it in the Facebook page of the coalition about evictions, about all the conditions, but so this is not extensive when I talk here. It's just if you don't pay rent, but that there are many things there. If you could pay the 7 first days after the notice to vacate, if it's the first notice to vacate, if the second you cannot pay, you just have to leave. Other reasons to end the lease early, landlords may apply to end the lease agreement if it's causing extensive damage to the rental unit of property, creating a health or safety risk, conducting illegal activities. This we are talking about here about landlord obligations. So I always say, by default, complain. If you see that a landlord is not complying with his obligations neither, you have to complain first, so you could finish the tenant first before them. How to file a complaint? So you have to submit a written request. Well, 15 days, any other complaints, just a reminder, if we're talking about increase 30 days, 15 days, any other complaint, we're talking about here, termination, applied online or a printed lane, there is a fax number, there is a phone number, going to the service New Brunswick, asking, calling is not a complaint. It has to be written, it has to be a form. You can find this form in Renting in New Brunswick website. There is also the UMB Legal Clinic, which is province-wide. It's in Fredericton, but you can call, you can send an email. They are helping tenants when the case is a little bit more complicated. Students can represent tenants, supervised by the director of the clinic, who of course is a lawyer. This is my email. If you have a concrete case that you would like to share, and I'm gonna stop the recording for questions. Thank you. Okay, where I stop? Okay, stop share. Stop recording.